Talkback lawyer David Whiting is saddled up, chained to the desk and ready to go. 1300 222 774 if you'd like some free legal advice from David. 1300 222 774. That's the number to join in on. And just to explain, no, we can't take questions by email or by text message because, as regular listeners to the segment will know, David almost always has to ask some extra questions and get extra information, and it's also not fair to people who sit patiently waiting on the talkback if we jump the queue with an email or a text question. 1300 222 774 for free legal advice from David Whiting. David, good morning to you.
Good morning, John.
Any developments on the legal front?
Well, some years ago, the government introduced some unfair contracts legislation that snuck in. It started in November last year, and it effectively allows what amounts to small business to have a go at unfair contracts. The ACCC is now running a case against a waste management company and their standard form contracts and how they treat small businesses. So it's interesting. So if you've got a small business and you buy from someone else, because it's not consumer law, in the sense, but it's consumer law for business.
Okay.
So if you're a little business, and a little business is, I think, somebody turning over less than $3 million a year.
Oh, that's not little.
In the great scheme of things, it's little, but it's a huge number of businesses.
Yep.
Then you've got the ability to wander off to VCAT or to the federal court, and bring a proceeding saying, this contract is unfair, I want it rewritten. So when the legislation came out, the expectation was that there would be a lot more tweaking of contracts. The banks have now tweaked all their standard form loan contracts, which basically said, I can take the money back as soon as it starts to rain. And they're now being reworked to deal with notice and other requirements. So that's
very one-sided, all those sort of things. I mean, you can't seriously expect, if you're negotiating, a loan with a bank, you can't really tamper with the standard form contracts. They're not going to negotiate with you over that.
No, but this is about changing the standard form.
Yeah.
So they're not. So if you get an overdraft, the overdraft says it's repayable when I tell you to repay it. So it's not an overdraft for a period of time.
No, it's sort of at call. Yeah.
Yes. So
if it's unsecured, you mean?
Either way. A housing loan is different. So if let's not panic people with housing loans.
No, because that's locked in for a term.
Yes, and if you make the payments, then that's really the end of the deal, unless the house burns down. But if you have got a business loan with a bank, then all of the banks have recently changed their standard form contracts to accommodate their view of the unfair contracts legislation, and anyone who had a contract signed before November last year is still at the whim of the banks, although there's a suggestion that they're reviewing those as well. So that's my first one.
Okay, now Kelly O'Dwyer, the Minister for Financial Services, told us earlier this morning that in order to deal with the problem of what's called a Phoenix company, which is where someone, usually pretty shonky, shuts down on Friday and reopens on Monday doing exactly the same things, often in the same place, but just with a new corporate structure.
Yes. It sounds remarkably like the one that closed on Friday.
Yeah,
yes.
And usually leaving behind significant debts, particularly to the tax office, but sometimes dudding other people as well. To deal with that, they're going to start providing a requirement that directors have individual identification numbers to be a company director. So you're going to have an ABN and a ACN for a company number as well as an ABN. You've got a tax file number for individuals. Now you're going to have an Australian company director's number. You've got a driver's licence number and a passport number, and it just goes on, Medicare number, it goes on and on and on.
Did the Minister indicate to you how many there are?
Oh, there's hundreds and hundreds of thousands, surely.
Well, that's a fair proportion of the population. Is this an ID card by another means?
I put that to her and said, why not call it an Australia card?
And was a slight twinge on the side of the table?
No, I think she sort of went, yeah, right, nice one. But we are getting to this point where it's a bit silly, isn't it?
Well, John, if you in terms of the company directors, I actually think there's a real opportunity for rationalisation of registers. So at ASIC, because there are a whole lot of entries that I know are the same person, but they're described slightly differently. So you might be John Smith with a particular date of birth and a particular place of birth. You might be John Michael Smith with other details the same, or
you might be Michael John Smith on another form.
Yeah, and you might be the register might be old enough to not have your place of birth on it.
You might spell John different ways, with or without an H. You may spell Michael in a different way. And
So
just
all
try
of
and
those
fiddle it
things,
that way.
and you then say, well, because you do you check, you're trying to locate a particular person, you do a director search, and you find a whole lot of people that you're pretty sure are exactly the same person. So this would be a really neat way of reducing the number of directors.
But it's interesting because everyone's got a tax file number, but there's strict rules, privacy rules and the like, on what you do with it.
Yeah, I would be, one of the smart things you could do with this, if I'm a company director, then it's my obligation to keep my details up to date with ASIC, and then for every company of which I'm a director, that change would flow through. Because if let's say I'm a director of 40 companies, every time I change address, there are 40 forms that need to be lodged with ASIC to make the change.
Yes.
Under this model, hopefully there would be but one.
It would go through once. But it is becoming very cumbersome, is, I guess, the point. Most other countries do have a standard ID, and you've got to carry it with you. I don't like that idea, and it's one of the great features of Australian openness that we don't have compulsory ID that you have to carry on you all the time. But that's where most other jurisdictions have ended up. Well,
and you can also get uniformity of numbers, John. The Singapore passport number is your ID card.
Yeah.
So your Singapore ID card has a number on it that is also the one on your passport. So you get a new passport, you've got the same number. So they're all interesting ways of reducing the number of numbers. Now,
you wouldn't put Singapore on a pedestal as an open and transparent and democratic society, though, would you?
No, not in the slightest, John.
Exactly.
It's a fine city. You get fined for just about anything.
Yeah.
And they had posters. Okay. And my last one, John, is that there's a glorious case about to start in the Fed. It's a class action on deceptive and misleading conduct by gaming machine operators. And so that's the allegation. The allegation is that they're not fairly disclosing to you your risk of losing your money when you play with the machines.
No. Do you mean when you gamble you can lose?
Well, it's new to me, John. I'm not Crown's most regular customer. But in this particular one, there's a suggestion that the figures they put work something like this. The average payout, on average you will lose 12% of every bet that you have.
Yep.
So if you start with $100 and you have 10 bets, one after the other, how much can you expect to have left? The answer is $28. 10 rolls of the wheels, you end up with that. It's actually slightly worse than that in a practical sense, because the payouts that they use to calculate the 12% include the jackpots. And your chances of getting jackpot are astronomical. Yeah. So that's a case I'll look at with interest.
Yeah, and look, I think most people who gamble know that it's a bit of fun, but some people get completely sucked in and destroyed and ruined by it. So let's see what happens. 1300 222 774 if you've got a question for David Whiting. 1300 222 774. A couple of text messages. In Denmark, everyone gets a personal number for everything to do with the government, which makes things so much easier. Interesting. And why not your TFN, your tax file number, instead of a new one? Surely every director must have a TFN, but there's special restrictions and rules on tax file numbers being used for anything other than confidential communications with the tax office. So they would have to change, wouldn't they?
No, what you might do is that's my number for everything, but there might be an additional number or code that I need to use. The ATO is now doing voice recognition for... So if you ring the tax office, you go through a regime of, so your voice goes into a database, and when you ring, they say, "Oh, hello, John."
No.
Yes.
Is that right? Well, she did talk about biometrics, but wouldn't be specific about what exactly it was when we talked to Kelly O'Dwyer. James from Brunswick, you're through to David Whiting. Good morning to you, James.
Good morning. You guys are scaring me a lot, because voice recognition from the ATO...
Yes, they've got it now, John.
James,
sorry. Yep.
That's incredible. Just as a normal, I guess, law-abiding citizen, that's very scary. I don't need to be observed like that. But anyway, I'm digressing. Now, I'm a driving instructor. I was driving along during a lesson, and I was hit by someone who was at fault.
Sorry, your car was hit or you were hit?
Yes, someone went through a giveaway sign, didn't give way, and hit my car.
Hit your car, not you.
I was without. So there wasn't an issue of identifying the other driver. The car's been fixed, etc. But I was without my car and therefore without income for 2 days.
Yes.
Now, is there any recompense or is there any way of actually doing anything about that loss of income for 2 days?
Yes, but your claim is against the driver of the other car.
Yes.
It's probably not a claim that you can make on your own insurer, but you could have a look at the terms of the insurance policy. It generally speaking doesn't cover loss of income.
I've spoken to the insurance and they don't want anything to do with it. So.
Okay, then your action is against the other driver. Do you know what insurance company they have?
I
don't have to tell me who it is, but if you knew who it was, you could actually have a look at the terms of their insurance policy, standard form contracts working for you.
Yeah, and they're not sort of saying that they're open and liable. So is it a VCAT thing or is it a...
No, it's a magistrates court matter.
Yep.
And you're entitled to the net effect of your loss of income.
Lovely. Is there a upper limit of whatever it was?
$100,000 in the magistrates court.
You
may be a very good driving instructor.
That'll be 2 days' work, wouldn't it, James?
No. It was a little under $1,000. So
So go for your life.
Thank you very, very much.
But it's the driver. All right. Thank you, James.
Not a problem. Thank you.
So you've got to make sure the driver's actually got something. You can't get money from a stone. Amanda in Pakenham, you're through to David. Good morning to you.
Yes, hello, John and David. Thanks for taking my call. Look, I've been running a business for the last 20 years. I go into people's homes, make leaded glass windows, install them, wander off.
Sorry, you make what?
Leaded glass windows.
She does lead lights.
Exactly.
Yep. Okay,
right. People don't know what that means. So.
Oh, I'm sorry. I'm just older than that, the problem, Amanda. Yes.
Fair enough.
Yep.
Look, for various reasons, I want to shut it down. I've gone to the ASIC website and I've looked at what I need to do. That's all fine. My question is, during the life of my business, I've maintained insurance, public liability insurance.
Yes.
Do I shut that down the day I shut my business, or does that need to exist beyond the business?
Well, hang on. Let's divide this into two. Have you got product liability insurance?
Yes.
Okay, because there's product liability and personal, and there's public liability, which is you damage something if you went on their premises. But if you were to make a lead light window for me and it collapsed and hurt somebody in my home, that's a product liability claim.
Yep.
Once you've stopped going to people's homes, I don't see any point in maintaining the public liability element of the policy. But what you might see is whether it's possible to get what the law calls run-off cover for the other. So,
what's run-off cover?
Well, when you have there are two types of insurance policies, John: claims made and claims incurred.
Yes.
Okay. A claims incurred policy is when in Amanda's case, she makes a window that fails. All right.
What, it leaks or breaks or doesn't
doesn't measure up in some way.
Right.
And if she did that 4 years ago and the claim was made today, and 4 years ago she had a claims incurred policy, she would get cover. Right? It runs off, it continues to run. She's got cover, provided that it's brought within a 6-year period. Amanda has cover for 6 years from the time when she does something wrong or badly.
So that needs to be maintained for about 6 years?
No. If you have a claims incurred product liability policy, you don't need to do anything. You could stop the day you close your business. If you have a claims made policy, then the insurance company, then you need to have insurance in place at the time someone writes you a letter of demand that says, Amanda, my window has failed. It has damaged my antique couch and a few other things, and I'm making a claim against you for $20,000. So that's a claims made policy is when you get the demand notifying you of the claim. A claims incurred policy is when you've got cover that continues to run for a period after you do the act that causes the problem. Does that make it clearer? It takes a long time to get your head around it, but that's the way it works. So what you really want to do you use an insurance broker?
Yes.
Then ring your insurance broker, find out whether you have a claims incurred or a claims made policy, and what you've had all of the time that you've been in business for at least the last 6 years. Yep. And then what you want to do is arrange what's called run-off cover.
Okay.
All right? If you have a claims made policy, you want run-off cover.
And how long would that need to go on for in terms of years, do you think?
Well, it would be a maximum of 6, but each year your premium should go down
because the
possible number of claims diminishes each year.
That's fantastic. Thank you, David.
Thanks, Amanda.
All right, that's certainly crossing the T's and dotting the I's. Text message, called the bank to get a password reset, went through a series of questions, got a message afterwards that they will use voice recognition for me in the future when I call, says Mirail. And the ATO, according to Chris in Mount Waverley, use voice recognition. You have to repeat the phrase, in Australia, my voice identifies me. And that's when they say, OK, in future, we know who you are.
There you go.
In Australia, my voice identifies me, and that's all they need in order to set up a data bank on you.
Yes.
Gosh. I won't even start
Not everything's
on that.
positive, John.
No, we should try it with the talkback. Ken from Doncaster, good morning.
Good
Ken.
morning, John and David. Yeah, this is a question about removing a caveat on a will.
Yes.
It's in Queensland. It's a friend I'm ringing on behalf of. The deceased was a close friend. I don't know if you could say they were partners, but they've been close friends for a number of years, 20 or 30 years.
Okay, Ken, a caveat is a notice lodged against a will by a person who doesn't want probate of that will being granted. Now, sometimes there can be different reasons for that. One is that they want to have notice when an application for grant of probate is lodged, in which case in Victoria they're using the wrong form, but it's what everybody does. And the other one is where you really don't want probate of that will granted because you think that there might have been undue influence, lack of testamentary capacity, all sorts of things.
So it puts a brake on the processing of the estate.
It's the latter, is it?
Yeah, I think so.
Well, then what will happen is that your friend in Queensland will make an application for grant of probate, and the caveator will be required to issue proceedings to enforce the caveat.
Right. Well, the legal advice that she's received, she's been getting a solicitor.
Yes.
And he said there's 3 options. One is to go to court to have the caveat removed.
Yes.
And that'll cost $20,000 plus a barrister $10,000.
Yes.
And court costs.
Yep.
Or to negotiate a settlement with the other party.
Well, again, in a sense, though, Ken, that really depends why the caveat's been lodged. If the caveat's been lodged, if I lodge a caveat because I think I should have been provided for in the person's will, what I really want to do is be in a position where I know where probate has been granted so that I can challenge the will.
So...
But it is misused sometimes. People say, I can put a caveat on, that'll annoy you and you'll pay me to go away.
Yes, I think that's sort of what she suspects.
Yeah, and people who sometimes have very good grounds use a caveat to make sure they're not dudded in the estate, but sometimes people with very slim grounds or prospects of success use it to create nuisance value, and having created nuisance value, they then get paid to go away.
Yes.
Yeah.
So the answer is, which is the... it depends upon the prospects of success. If you're absolutely certain that the caveat was without merit, then you run the argument and put them to their proof.
Right.
If the deceased wasn't as robust in an intellectual sense when the will was made, you might go along and say, well, I might win, I might lose. How might we resolve this issue? You're making a commercial decision. And there are a whole lot of people who are very upset that you make a commercial decision on an issue of that kind. And the question will really be, you've got to assess the merits of the claim. Well, you've got to assess 2 things. What I consider to be the moral elements of the claim, and then whether or not they would succeed if they ran it. All right?
So can they go ahead... Could she go ahead and make application for probate?
Yes, but it would need to involve getting rid of the caveat. The caveat wouldn't. They wouldn't grant probate while the caveat's in place. So she needs to deal with the caveat in some form, and she either takes it on or haggles.
And there have been some noted examples in the courts recently where people have fought the attempts to hold up an estate, and people have been made to pay hefty bills of costs for losing claims against estates for entitlements that the court did not establish.
Yep.
And
so
it cuts both ways. There was a famous one in Western Australia, I think, where someone went for millions of dollars from a mining magnate's estate, lost, and had to pay a huge amount in costs.
Yeah.
All right, Ken?
In one sense, Ken, the problem that you and I are having is that you're not the applicant. You're relaying a message on behalf of someone.
Yeah.
And so your friend in Queensland needs to sit down with the lawyer that they've chosen and have a discussion about what is the most effective way to deal with the issue. That's take it on or endeavour to resolve it by negotiation.
Good luck with it, Ken. I have any number of people now saying that I've given away my voice ID by reading out that phrase, in Australia, my voice is known by, blah, blah. And they can now access my ATO records. How good is security? And I don't think you could do that, actually, but there you go. Good luck. If indeed you think it's as simple as that, I'm sure the system's a little more robust than that. And if it isn't, we're about to find out.
Yes.
Might say accessing my ATO records would be a remarkably unrewarding exercise. Joseph in Box Hill, good morning to you.
G'day, John. G'day, David.
Joseph, yep.
Yeah, it's not my real name, but I'm...
Really?
Yeah,
you answer to it, that'll do. Yep.
Nod, nod, and a wink, wink.
Yes.
Look, currently, Mental Health Act currently have a brother, a family member, who is having a hearing this morning at a hospital. He's very mentally unwell.
Yes.
And he's being placed on a community order. What happens under that community order, and what will happen to him?
Is the hearing before the Mental Health Review Board?
Yes.
Okay, is it to do with voluntary or involuntary detention?
Involuntary detention.
Right, so I think that's called, is that Section 8? I've forgotten, Section 8, yep, application.
So he's currently in.
Yep.
We're now talking about letting him out. And the question is, what terms do we let him out on? Is that the question?
Yes,
Yep.
that's right. And, there's AVOs out against, so many family members, including myself, have AVOs out against him because he's, uncontrollable.
Yep.
And so it's a case of wanting to protect myself, and also what are the restrictions that are placed upon him.
Is someone appearing for the family at the Mental Health Review Board hearing?
No, we decided not to.
Because?
Should we? Well,
in a sense, Joseph, this is about making submissions to the people who are determining your brother's terms of release in circumstances where you don't want them to know everything.
Right.
Right. So even if you had not appeared, a submission would have been worthwhile. That here are a series of, you may or may not be aware that there are these personal safety intervention orders that are made out against him in respect of the following people. At broadly the following locations.
Well, look, the hospital's well aware of the AVOs, and I think that they will be mentioned.
Yes.
You think?
I'd rather be sure, but let's keep going.
Exactly, that's the issue here. But that's precisely...
Now you've got me quite anxious, John.
Well, I'm not wanting to get you anxious, but you've rung for advice, and
yes. If
you have matters that you think are relevant and the tribunal doesn't hear them, then they can't take them into account.
Okay. Well, what does the tribunal do then? It stipulates what he can and can't do when he's released from.
It can cover just about anything. It can determine how often he's required to attend for treatment. It can determine where he's required to live. He might be required to report. There are a whole series of things that they make them do. And it's, in a sense, it's a customised regime. So it may be that he's required to attend for treatment 3 days a week. It could be all sorts of things like that. It could be
because there's a young daughter involved in the former partner, and it's messy and it's complicated, and of course he's just not well. He's very, very unwell, and I have a lot of compassion for the man in his situation, and certainly don't want to see him getting unwell again. I mean, this is the second time now that he's ended up where he has.
Yep.
And
so what you need to do, Joseph, is you need to try and find out if you can get details of the order that's made.
Yes.
In this privacy mad world, you may not find out.
Yes.
But what you should have, and every member in your family group who's affected should have, copies of each of the orders that have been made against him, so that in the event that you do need to ring the police station,
Yes.
then you're able to say, he's turned up at my doorstep, that's in breach of a personal safety intervention order made on such and such a day, and it's still current. Here's the reference number, I've got a copy. Can you please help?
Oh, okay.
All right, so,
All right.
in a sense, it's resourcing the people who are likely to be impacted.
Okay. Now, where can I find more information about this?
There's two places you can look at. Their law handbook is fantastic. So it's the lawhandbook.net.au.
Is that the one Jon Faine edited many years ago?
Indeed it is. But to be really honest, Joseph, they've improved it since then.
Oh, okay. Good to know.
Just for the record, I was the first editor of the Law Handbook in its current form. I inherited it as a loose leaf, updatable book and turned it into an annual volume, something I'm absolutely very proud of. And
Good on you.
Not for a moment will I have that taken away.
The last thing, Joseph, is that there is a mental health legal service.
Oh, yes.
Have a look at their website. You will find
a lot of
additional information there. It's skewed towards the people who suffer from the mental health, but you can actually get a lot of information that will help you.
All right. Look, thank you very much, gentlemen.
Thank you,
All right,
Joseph.
good on you.
And
Okay,
Joseph,
bye.
good luck. And
Thank you.
helping your brother by being involved in these proceedings in a constructive way is a wonderful thing to do. It shouldn't and doesn't mean, though, that you should in any way make anybody in your family vulnerable. You've got to find a way of doing the two.
Yes, I agree.
I mean, people who are unwell get better and then they say thank you.
Well, I hope that's the case, John, because he believes he suffers from ADHD and not the condition that he's diagnosed with.
Let's leave that to the experts. I'm just trying to give you a bit of a hug through the radio.
All right, thank you. Good man.
All right.
Good man, John. All right, no worries, mate. Thank you.
Take care. Can we squeeze another one or two in, David, after the news headlines?
Sure.
Thank you very much. David Whiting, our talkback lawyer, helping you with free legal advice. Let's continue with your calls with our talkback lawyer, David Whiting. In Glen Iris, Indiana, good morning to you.
Yes, good morning.
Go right ahead. You're through to David.
Well, I worked for a company for 22 years and I'm 62. I advised them earlier this year that I'd planned to retire in August next year. They, at the time, didn't say anything. Then in June, I was ambushed at home time and given a letter saying that they wanted me to accept an offer of 4 months' salary and pretend to retire.
They actually put that in a letter?
Yes, they did.
Wow, okay.
4 months' salary or pretend to retire. And even at the back of this deed of release thing that I had to sign was the speech he was going to make at my retirement lunch.
Wow, that's good. Could you get
Did you get to choose the menu?
Edit it, yeah.
No, well, it freaked me out so much. Obviously, I didn't accept it.
Yes.
I went to a lawyer and I lodged a writ in the county court. Meanwhile, the traumatic effects of this.
So why was this not a fair work matter? Why are you in the county court?
Well, because I'm paid too much. I was an executive.
Okay, yep.
Yeah. So I lodged a writ in the county court, but meanwhile, I have had such a traumatic effect because of this. I'm on work cover. Work cover has accepted the claim, and this company I worked for are obviously paying me work cover. My question is, I've been offered an amount to settle, which is too small, I'm not going to take it, but I'm wondering whether, I know that when we lodged the writ, it asked about whether I was seeking work, and I know that any money that you earn after you leave comes off that amount that you are granted.
So you're in court already with them, Indiana, so you've got lawyers who are looking after your interests. So why do you think David's in a better position than them to fill in some of the gaps in this?
Well, there's only one gap. It is whether this work cover I'm being paid will reduce the amount of my settlement.
But aren't your lawyers already deeply embedded in your claim, the best people to answer that, rather than David, who's got no documents and no familiarity with the nitty-gritty of your case?
Well, I've asked them the question and they're saying they are not work cover lawyers. which I found a bit strange.
So why did they take your job? If they didn't have the, as a lawyer, we've got to be satisfied that we've got the appropriate skills to handle your case when we take your case.
Where the writ is not to do with work cover, it's to do with, breach of contract, that this wasn't.
So they fired you. Is that what you said? They did fire you?
They fired me.
Okay,
yes.
All right. And they were saying that's a wrongful dismissal. You brought an action for damages. You're currently on work cover payments. Yes. Not for you, Indiana, having regard to Jon's comments, but for everybody else, I'll tell you next week. And it makes no difference to you because you're not taking them. All right. So, but the answer is I'll have an answer for next week in relation to. On the basis that it's a wrongful dismissal action. You're currently on wrongful on payments, and the question then arises: is if you take the whatever offer is made, does it? Are you required to repay?
Does it come off that settlement?
Yes.
And the alarm bells are ringing, Indiana, because if the settlement is for lost earnings and income, work cover will say, well, you can't double dip because that's what we're paying you for. Now you have to pay us back some, and that regularly happens.
It's not lost earnings. It is more like, they dismiss me with 5 weeks' notice.
Yeah. But if indeed there is within the settlement a component that covers the same things as work cover, then work cover will ask for repayments, and that's a consistent feature of these settlements, David. They've got to be structured very carefully.
If you look at it, a long time ago, you used to make a claim. You used to get paid compensation that didn't include medical and like expenses, right? And that way you didn't have to pay anything back to Medicare. The law changed and now you have to, right? Now, in terms of work cover payments, I don't know. But if you think about it, you have been receiving... So you make a claim for wrongful dismissal and your claim is, let's be outrageous, payment through till August next year, which is when you plan to retire. Now, if you're receiving work cover payments at the moment, you're getting some money in respect of part of that period. So if I was the judge and was to make an order in compensation to compensate you for your loss of income from the time of cessation of employment to August next year, it would be logical either by making you require to repay them or by deducting it from your order, the repayment for that amount. One way or the other, but I'll give you a better answer next week.
I'm equally concerned about Indiana getting representation from lawyers who are not across the nitty-gritty of the jurisdiction they're working in. That's not real good.
Well, why would you take on a wrongful dismissal action in circumstances where your client's on work cover and not being able to deal with the impact of both?
And represent them globally and protect their interests. That's why this is all now so highly specialised.
I would suggest that, at the very least, I'd be getting a counsel's opinion who's running the case, even if the solicitor who's representing you doesn't have the personal skill set.
And if not counsel, well, you just ring up a mate who works in the area and say, hey, I've never had to deal with this before. How do I fix this?
What's the short answer?
Yeah, yes. Pretty much how it works. Di in Bundoora, you'll be our last caller today with David. Morning, Di.
Good morning, John. Good morning, David. My question is about a mortgage repayment insurance cover.
Yes.
I had a mortgage renewed with a new bank and took out that insurance. And on the medical questionnaire, they ask you, about any kind of tests that you've had.
Yes.
And I had a fibroid lump on my breast. And it came back benign, obviously, because it was discovered to be a fibroid.
Mm-hmm.
Hooray for you.
Yeah, it was good news. Anyway, the insurance company put a clause in saying they won't cover me for any kind of tumours of the breast should it happen in the future. Is that fair and reasonable?
I've never actually thought of insurance companies as being fair and reasonable, Di, but I suppose it's possible. What they're doing is they're assessing you. It's on every insurance policy that you get. It's they're trying to, in a sense, limit their risk of paying you out. So the answer would be, and now they can do so many tests that they could actually make it impossible for you to get insurance for anything you might likely get.
Yeah.
So the answer would be it's probably what they're entitled to do.
Right. Right.
You might look at, remember the discussions that we had on the radio in the last couple of years over what's the definition of a heart attack? And there were lots of different insurance companies who had different definitions. Some would pay you, some wouldn't.
Right.
Right? Why not? Are you required to use this mortgage insurer by your lender?
Yeah, well, they're the only ones that they work with, so it kind of limits my options, yeah.
Yes.
Okay,
the answer is I think they're entitled to do it.
Okay.
It might be worth a discussion about whether it's, whether in a sense it's just they're making it far too precise. So the concept of insurance I insure 1 million people because I only expect to pay out 5.
Yeah, but there's an insurance ombudsman. If nothing else, a bit of correspondence might not go astray.
No, perfect.
All right, Di.
Thanks, John. Okay.
Good luck, and good luck to all of our callers. Apologies if you didn't get through today, but
Thank
David,
you, John.
Look forward to seeing you next week. David Whiting, our talkback lawyer, helping you with free legal advice.